we are discussing a very interesting subject that is on the issue of mediation in India, which is the Draft Mediation Bill 2021, which is 2021. Why do we discuss this? Time and again, we have seen now judges from the Supreme Court also saying that mediation should be encouraged in this country. India has a rate of mediation that leaves a lot to be answered. We need to do a lot more in this area. And so we've got an eminent panel to discuss this issue with us today, the bill as well as other issues surrounding it that come to their mind. May I introduce you to Michelle Kalipitis, QC is a Queen's Counsel based out of London. He joins us on Legally Speaking for the first time. I welcome him to the program. I have with me Dr. Aman Hingorani. He's a well-known mediator and also an advocate of the Supreme Court of India. He's a familiar face on Legally Speaking. Pleasure to see you again, Dr. Hingorani. I also welcome Anurup Omkar. He is a mediator on the panels of World Bank, Asian Development Bank and United Nations. Also has written a book on the subject. Anurup, welcome to the program. May I request Dr. Aman Hingorani to lay the ground of this issue first before we move on the draft mediation bill. Your opening comments on the issue.
Well, lovely to be here, Tarun. Well, this is the bill was put out for consultation and to take views of different stakeholders. I'm not impressed by the bill, very frankly, because of a number of reasons which I've already penned in an article which was published recently, because I feel it dilutes the principles of confidentiality, dilutes the principle of mediation being a voluntary process, has provisions which are, I would say, unknown to law, particularly when you talk about limitation of challenging an agreement on the ground of fraud within 4 months of the receipt of settlement agreement and so on and so forth. So, there plenty, I mean, I know this opening statement only, so I'll just keep it brief, but there are plenty of provisions out here which I feel should be relooked at. It needs to be re-examined. Also, the issue of mandatory pre-trial mediation or pre-litigation mediation in the absence of infrastructure, in the absence of adequate number of mediators. Can we really have, I mean, a pre-trial mediation is something I really welcome, but can we make it mandatory without first providing the infrastructure and the mediators? And also, can we really impose it on parties who are unwilling to go in for mediation? We can really tell a person, you don't want mediation, but you jolly well go for mediation, sit for one complete session, and then opt out if you don't want to stay there. So would that mean we are blocking access to the court? Okay. That nobody can file a case till you go through this process, and that brings a broader issue of access to justice. These provisions may be constitutionally vulnerable.
Okay.
So, you know, there are many aspects to it, but of course,
yes, this is just an opening comment. We'll get on to the specifics. Yes. Anurup Omkar, your opening comment before I move on to QC, Michelle.
Tarun, how I view it is a great step forward. But in a country like India, I don't think there is any law which has never been put to scrutiny or criticism when it has been rolled out. All my opening comments, it is a very great step for a country like India, having now been a signatory of Singapore Convention, at least to make an attempt of introducing a mediation bill which has been a neglected child for long. That's okay. All from my end.
Okay, I'll go to Michelle Kalipitis, QC. So if I may ask you, based on your international experience in the field of mediation, what is your take on market shaping up and public responding to mediation after legislations have been put in place in the country?
That's a very big question, Tarun. First, let me say I'm delighted to be invited, and thank you for welcoming me to your program. I wish we had something similar in England, but we don't. I'm also very embarrassed by the fact that I'm being asked to talk about a draft mediation bill for India, when England, although we've been mediating now for over 20 years, hasn't got anywhere near drafting a bill, and I'm constantly fighting the battle against deaf ears. There's always something much more important. Let me answer your question this way, if I may. We had all these arguments, and the same arguments that Dr. Aman Hingorani has just put forward, when we were discussing the European Code of Conduct for Mediators and subsequently the directive on mediation. And I was asked to give evidence before the European Committee, before the Parliament. And I said to them, the drive for mediation will come not from the top, i.e. the judiciary or Parliament. It will come from the commercial community. Those of you who studied law, and I know that all of you have, will remember that in medieval times, there were markets held. And at the end of every market, there was a court, which was to resolve all the issues that had arisen between traders and the public, over the value of the goods, the state of the goods. All these issues were tried there and then by the courts, which were called pie powder, you remember, from the French pied pute, dusty feet. So they resolved all the issues straight away because that's what the commercial community wanted. And there developed then the mercantile law, which became widespread through Europe before English common law, for example, ever got anywhere near it. And in Blackstone's commentaries, they recognized that the commercial courts and the courts of pie powder are the most efficient at resolving problems than any court in England at that time. And that was written in the 19th century. And so I say to the answer to your question, Tarun, is this. The commercial community will want to have a support for their desire to have their problems and disputes resolved efficiently and quickly. And mediation does provide that, provided three things are fulfilled. First, the courts support mediation. And I don't believe that making it mandatory, frankly, is the right way to go. For very small disputes, for online disputes, for consumer disputes, sometimes it works. But for large commercial disputes, which is what we are talking about, particularly as India is one of the largest international economies in the world, and therefore its large companies and organizations all will have these international disputes. For them, it's of critical importance that issues are resolved speedily and at minimum cost to them. And the courts can encourage that, not by making it mandatory, but introducing, if I may respectfully suggest, the similar sort of regime the courts in England introduced, which was to penalize parties who refused to mediate unreasonably in costs. Now, the English cost system is notoriously expensive. I know India has a cost regime which is very similar, but it's quite possible for courts to introduce that regime to say, mediation is there for you to use. If you unreasonably refuse to mediate without good cause, and even if you win the case, then you will not recover your costs. And that's a much more condign encouragement to mediation than any other. And so the fact of a Mediation Act doesn't necessarily mean that people will automatically embrace mediation. And so the opportunity for, if I may respectfully suggest to the Indian government and Parliament is this. You can lead the way rather than being driven the way by your commercial community. And you show leadership, you introduce a system which protects their interests, and then you will succeed. And there are many mediation acts in the world. Several are highly commendable. There are evidence acts in other parts of jurisdiction where they have set their face against mediation. And I'm afraid that the UK courts are too fond of wanting to inquire into mediation, and hence Dr. Hingorani's observation about confidentiality. But properly conducted mediation preserves the confidentiality, and that confidentiality needs to be protected by the courts by recognizing a special and separate mediation privilege, and not fall into the trap that the United Kingdom courts have fallen into by simply dismissing mediation as assisted without prejudice negotiations, giving them freedom to inquire into all sorts of reasons why a settlement should not be enforced, which bear no relation to the actual commercial reality of what we're done in the mediation. That's rather a long answer, Tarun, forgive me, but I hope that it covers most of the points that you raised.
Okay, point well taken. I'll take this another question to Dr. Aman Hingorani. If you compare Section 6 to the Section 12A of the Commercial Courts Act 2019, which is the Section 6 of the Mediation Bill, you notice that the Draft Mediation Bill does not in a sense, place a mandatory requirement before approach to the court. Unlike the case of the Commercial Courts Act 2019, the Draft Mediation Bill does not have a provision that says that the courts can resend parties back to mediation if they try to surpass this provision. Do you think such provisions are really effective? What is your opinion overall on making the mediation process mandatory?
You see, let me put it this way. I'll be very brief, but just to put it in proper perspective, nobody's against a mediation law.
Right.
We need a mediation law. This mediation bill equates mediation with conciliation. We already have a conciliation act from 1995,
Okay.
which talks about how to do conciliation. That's point one. The issue is of the bill in its present form, the proposed law. You have asked about commercial courts, and I completely agree with Michael. And in India, we have the amendment to the Commercial Courts Act, which basically provides that if there is a suit in which there's no immediate urgent relief sought, then you must go for institutional mediation. It's mandatory. The court's doors are not blocked. You can file a suit and make out a case that you need some interim relief. You can't compare that with the provisions of the bill or the mediation bill, which basically says in section 6, regardless of parties agreeing to go for mediation, regardless of the consent of the parties, regardless of whether the party wants mediation or not, no suit shall be instituted. You don't have a choice but to go for mediation. And you can't withdraw from mediation unless you have one complete sitting. So you block the access to court altogether. Section 8 says that, of course, a party can go to a court of law to make out an exceptional circumstance, exceptional situation for getting some immediate relief. There will be another set of litigation of what is exceptional circumstances. So basically, the provisions of this draft bill are not comparable with that of the Commercial Courts Act, number one. As here, there's a complete embargo of going to the court, unless you've gone through mediation. Now, having been in mediation for more than 20 years, practicing mediation for more than 20 years, I know what that means in real practice. It means that suppose, and in this bill basically talks about court annex mediation to be separate, lok adalat mediation to be separate. So we're basically talking about private mediation. Now, if I'm a private mediator, suppose somebody sends me a request for mediation. I request the other side to join in. That person has to come in once after one sitting or two sittings saying, well, I'm not available on this date or that date, till both parties appear before me. And I've explained the virtues of mediation to them, hoping to convert them into mediation process. The applicant I've sought mediation can't go to a court. This may take 6 months. So you actually, in a way, put an extra layer before a person can approach a court of law. And the right to court is a basic fundamental right. So there are many issues. I'm not even getting into the issue that you have infrastructure, do you have mediators who can be able to do this promptly, because this embargo is not for one case or two cases. It is across the board for all kinds of cases. So you can imagine the magnitude of this. And the apprehension of this is that mediation is going to be reduced to a mere formality, just as one hurdle to cross, that the school gates are closed, I must jump out of the gate to get away. Then you're going to damage the mediation movement. Mediation has been fully endorsed by our judiciary. It is a very, very powerful and effective tool. And it is appropriate to resolve many kinds of cases, give relief, which the courts can't give relief. So we are running the risk of damaging that by having this provision, which is not on the same footing as the Commercial Courts Act.
Point well taken. I'll go to Anurup Omkar here. Anurup, when I first discussed this show with you, you told me you were addressing people at the World Democracy Forum on community mediation. Now, coming to the bill, do you think the part 2 of the bill is in a sense well defined? What are your views on it?
See, Tarun, first of all, they're bringing in a part 2, imagining community mediation, because there would be hardly few community mediations in India where government will not be a stakeholder. So as we all know, government is the biggest litigant. So the imagining and bringing in a community mediation is at least a well thought of part of the legislation. However, I felt in certain sense the legislation has been loosely drafted by using the term may, writing things like this list is not exhaustive and tentative. It leaves room for a lot of subjectivity coming in. And where I come from, mediation bill or being a signatory to Singapore Convention, the idea of the government of India is to basically improve their World Bank rankings or improve the ease of doing business in India. And one of the, I'm sure many shows of yours have happened on this. One of the fantastic piece of legislation which have done well in the present time in the country and served the purpose to a greater extent has been the Insolvency and the Bankruptcy Code. Why has it worked well? Because they have capped things. They have been very objective in the way they have brought in. They are specified a timeline. Yes, there have been relaxations, but overall as a culture, the business community, the legal community, as well as the judicial community tried to adopt it. Similarly, herein they have brought in community mediation, but they have not been clearly explained what would amount to community mediation. And I saw they have delegated a lot of powers only at the state and district level. But, just off the head, I can think of, for years together, we have had water disputes between states in the country. Why can't they be referred to community mediation? And they have to be definitely be referred at a national level, which is absent in the legislation. They start from the state level. They have not assigned any national level authority which can take a call for community mediation, either in case of a water dispute, a student vis-a-vis, a dispute between a university, any dispute that say which the central government or the Supreme Court believes that is well suited for resolution rather than a judgment on it should be referred to community mediation.
Point well taken. I'll have my next question for Michelle Calapitis QC. May I ask you, as you'd be aware of the Singapore Convention on Mediation, do you see that there'll be a trickle-down effect on other countries across various geographies which are wanting to embrace mediation? India is a signatory, we all know, and is in the process of bringing a mediation legislation. Do you think that, the other South Asian nations will also, will be willing to embrace mediation in the coming few years?
Well, I think, Charles, I may say so, it's the countries in the southeast of Asia, as you call it, that have welcomed the Singapore Convention more than the European countries. Europe has set its face against the Singapore Convention for internal reasons, not least because there are 26 countries that all have to agree, and they can't. And of course, they are a civil law jurisdiction in the main. The common law jurisdictions, like Singapore, India, and Hong Kong, and the ones in the Pacific Islands, and the People's Republic of China and Russia, they have all accepted the convention and will be implementing it in due course. And that, to my mind, indicates that they have realized that the importance of the convention is that it is a preventative measure. It's not intended ever to be used because that means parties have honored their agreements. But it's there in case anybody is trying to extricate themselves from an agreed settlement, in which case you have a mechanism like you do with an arbitral award, that you can go to any country that has recognized the convention and enforce it. And that's a safeguard which UNCITRAL, from its researchers prior to setting up the Working Group 2, which I was a part of, in fact, identified as one of the worries of the international commercial community. And to allay that concern, they spent 2 years drafting the convention, and it is now not complete. So it's not perfect. It is complete, and it will be implemented. Time will tell whether it will need to be changed, but in the main, it is there as a mechanism to give support to mediation and the commercial community. And that, I think, is the importance of it.
Okay, point taken. I'll take this question to Dr. Aman Hingorani. The mediation bill in India, do you think it is an afterthought after the Singapore Convention was signed by the country?
No, you see, there has been a demand for a standalone mediation law because we had a lot of confusion about how is mediation and conciliation same or different. What is the status of a mediated settlement agreement and a conciliation settlement agreement? What are the provisions of the system of giving recognition or giving accreditation to mediators? You need to have some institute, the way you have a Bar Council of India. You do need to have some institutional mechanism, some place which can lay down the ethical guidelines for mediation. So there was a need, which was felt, that we should have a law. Now it's a different issue whether we built on the Conciliation Act or we supplant the Conciliation Act as it's thought to be done and have a standalone one law. So whichever way you want to do it, idea was that you did need a comprehensive legislation on mediation. Singapore Convention is basically on enforcement of commercial agreements by the parties to the convention. They don't talk about the process of mediation. So you needed something, you needed a law which actually dealt with, and one of the criticism again is, do we really need to demarcate online mediation separately, community mediation separately, or when they're all, rather than talking about one process. So I think the Singapore Convention has given us an opportunity to rationalize the mediation law. We have built on the definition of mediation, which is there in the Singapore Convention. Though, of course, again, the definition in Section 4 of the bill is incomplete. They forget the phrase that a mediator cannot impose a decision. That crucial part is not there in the definition in the bill, though it's there in the Singapore Convention. So we have built on it. We are borrowing aspects from it, but so I think it is given an opportunity for this to come in the mainstream, because we do need to mainstream mediation. There's no dispute about that. And so at least it started a conversation with the government. Like Anurup is saying, at least we have some initiative, something has come out of the whole thing. So I think the Singapore Convention actually acted as a catalyst to spur it. But I don't think that was the reason for this particular standalone law.
Okay. Point well taken. I'll go to Anurup Omkar. Anurup, the mediation bill clarifies that one of the grounds under which the settlement agreement may be held to be in conflict with public policy in India, if it is in contravention with what is called the fundamental policy of Indian law. Similar to the Arbitration and Conciliation Act 1996, the term fundamental policy of Indian law has not been defined in the bill, leaving the interpretation of this term to the wisdom of the courts. This whole fiasco has been dealt with in the Arbitration and the Conciliation Act of 1996 before, yet now again it has found its place here. What do you think on this issue?
See, Tarun, I think we as humans many a time learn from our mistakes, and at times we don't. And I don't want to comment exactly on the people who have drafted it. But see, Tarun, again, as I said, if you leave loose ends, you use very wider connotation, we tend to misutilize it. So when they had been dealing with this challenge of public policy for almost 2 decades now, my personal belief would be, in this case, they should have either defined public policy or they should have understood the real essence of mediation, which Michelle and Aman pointed out, that it's a voluntary process. When it is a voluntary process, you agree to mediate, you mediate, you disagree to mediate, you walk out freely. In both those given cases, where does the question of public policy come is my question, number one. Number two, if the mediator is well qualified, is a trained lawyer or any professional for that reason who understands law, and he has to be a signatory to the mediation settlement, in no remotest way he should be in a position to draft something which is against public policy. Because if you leave that loose end called, it can be challenged in public policy. And I think they have gone ahead and used terms like morality and stuff like that. How do you define all these terms? When you draft a legislation, you want to bring finality to things. You don't want to create further chaos, because we are bringing mediation because a lot of things the traditional way have not been resolved well, or there is backlog, or there is lack of judges to disputes ratio. You are bringing in mediation. Again, within a mediation act, if you bring in so much of confusion, then again you are leaving so many doors for interpretation. And we are great at doing it. The lawyer community would be more interested in interpreting the law rather than using it. So my point would be, either they should define public policy or should do away with by defining mediation practice in a totality, explaining how voluntary it is in nature, how you are free to use and free not to use it.
Okay, point well taken. Now, because we are out of time on the program, I want to ask all my three panelists if they want to make any final comment before we end the show. Aman, you want to say something?
Well, I would simply emphasize that that the bill, the provisions of the bill, particularly those which, according to me, are against the elementary propositions of law, they must be re-examined. For instance, as I started in the opening comments, one of the grounds of challenging a mediated settlement is if it's vitiated by fraud. And a time limit has been given that you can challenge this within 3 months from the date you have received a copy of the settlement agreement, and that can be extended by another month by the court. Fraud vitiates everything, it unravels everything. And even if a limitation is prescribed, it is always from the date of discovery of fraud, not from a predetermined event like a receipt of a settlement agreement. So these kind of provisions, confidentiality, talks about a settlement agreement being deposited. Confidentiality extends to the settlement agreement, except for where you need to enforce it. It contemplates audio-video recording of mediation proceedings. That's unheard of. It does not even have a provision, a simple provision, that if a party says, please do not disclose this to the other side. If a party tells a mediator, please do not disclose this to the other side, the mediator cannot disclose. That was Section 70 of the Conciliation Act. The bill has no similar provision. It has no prohibition that a mediator cannot act as an arbitrator or a counsel unless as agreed by the party. That was Section 80 of the Conciliation Act. Again, that's missing. So if you take away your neutrality, you take away confidentiality, you take away the voluntary nature of the process, you bring in grounds of challenge which are artificial or which are misconceived, I would say, and you put artificial limitations. You put limitations of 90 days plus 90 days in a private mediation to be completed. I might choose to be, if I'm a party and I want to go to a mediator, I might want to mediate for a year. Why should there be a time limit at all? How do you tie up online mediation with saying the place of mediation is tied up with the territorial jurisdiction of the court? How does that work for online mediation? There's several, I can go on and on. I know it's a closing comment, but I can list out the kind of flaws which I feel must be re-examined. As well, this is going to be, it will be a lawyer's delight, but otherwise it's going to be a nightmare for those who actually have to do mediation.
That's a good note to end the show, because I see many points that Dr. Amar Ningorani raised. We will see if there are any changes to the draft mediation bill before it goes to Parliament. I think the cabinet has yet not seen it. So I think before it goes to cabinet, we will have to see if any changes are incorporated. I'm privy to the fact that Dr. Anwar Ningorani has also given some inputs, of course. Before we end the show, of course, QC Michel has a point to make.
Two things. Dr. Ningorani, would you be kind enough to send me a copy of your article? Because I'd be very interested to read it. And secondly, I see this as a good start by India. It's a draft bill, and I think it's the duty of the experienced mediators like Dr. Ningorani and Arup to help the government get it right. And so I don't think it should be condemned. On the contrary, I think it should be applauded. It is our job as experienced mediators who know actually what happens in a mediation to help them fashion it in a way that will make it helpful. And I want to say is good luck to you. Bravo.
We're totally out of time. Anurup, 30 seconds before we end.
So Tarun, just quickly summarizing, the intent is amazing. The passion is great, but the draft seems like a child lost in a candy shop.
Right. So thank you, Anurup, QC Michelle Calipites, Dr. Aman Hingorani, sparing time for joining us on this issue. May I request all of you to join me again on my show when the bill passes cabinet's muster and goes to parliament. That is when we'll really get to discuss the opinions, because of course then it will be final, because given that the bill will be passed if it is in parliament, there's not a coalition government, that bill gets stalled, the bill will pass. So then it will be, when the bill is presented, we know it's for final. But thank you so much for joining, all of you. Thank you.
Thank you, Tarun.
Thank you very much for inviting me. Thank you.
Bye-bye, guys.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.